Once again, it's with a great pleasure that we accepted the invitation of Professor Vasco Pereira da Silva to participate in the Alpes Law Review and to whom we address our deepest thanks. Under the topic of law and culture, and knowing that our academic work is focused on the legal history perspective, immediately came to our mind the possibility to analyze the difficulties or restraints felt in Portugal by those who wanted to spread their thoughts and subsequently publish their writings before the concept of freedom of speech was assumed. In this context, the purpose of our work lies in the presentation of the main characteristics of an institution named Royal Censorship Court, created in 1768 during the Enlightened despotism, whose most important exponent was Sebastião José de Carvalho e Mel, the Secretary of State of the Portuguese King Joseph I. The model once adopted was not an innovation in the European context. In fact, it is already possible to identify other examples, such as the Commission for Literary Censorship, implemented a few years earlier in Austria, known as the Bücherzensur-Kommission, whose existence and benefits were told to the same Secretary of State by his friend and personal physician, Gerhard von Swieten, during his stay in Wien. The second case that can be mentioned corresponds to the Consejo de Castilla, a board founded in Spain that was responsible for carrying out a prior censorship while the Inquisition kept the control over the printed texts. Thirdly, the Direction de la Librairie that exercised all control over the French book market. Without neglecting the formal procedures concerning the creation of the new institution, the Crown started by consulting the most important jurists, the General Council of the Holy Office of the Portuguese Inquisition, as well as several canonists and theologians. We must remind that at the time, freedom of thought and speech was a total absent concept. That is, depending on the state, the right to control all sorts of writings was exercised either by a political, administrative, or religious authority. Moreover, not only the right of printing was specially conceded by the monarch, solution that assured all means to prevent counterfeiting, but also book trade was permanently under the surveillance of another state institution that in Portugal took the name of General Policy Intendancy. In simpler terms, in the context of the 18th century, control was one of the key words for political success, and during the period from 1768 to 1787, it was up to the Royal Censorship Court to combine the censorship, the inspective, and jurisdictional nature. Established like this, the new legal measure abolished the archetype introduced in the 16th century during the reign of John III, based on the performance of three different bodies that had been called to approve the printing of all sorts of taxes and leaflets. Those entities were the Inquisition, the diocesan authorities, and a political and judicial crown court known as Desembargo do Paço. Despite their acting, we must underline that the inspection was somehow disjointed, divided, and weakened. Besides, it's undeniable that the process was extremely slow, proving itself incapable of fully controlling the number of clandestine publications that were spread. Once officially declared in the decree of the 5th of April 1768, it did not take too much time for the sovereign to appoint the president, the ordinary and extraordinary deputies of the new institution. Among the chosen members, we can find some clergymen, although they did not act directly on behalf of the Church, and several secular jurists. As an example of those two categories, we can name the Cardinal João Cosme da Cunha as the first president. Followed 5 years later by the bishop from Évora, Manuel do Cenáculo, while as a secular judge we can point out João Pereira Ramos de Azevedo Coutinho, a judge from the Court of Appeal of Oporto. To be nominated, the deputies needed to fulfill several requirements, such as commendable probity, great prudence, maturity of judgment, total impartiality, and respect for the common good, along with a deep knowledge of the ancient and living languages. Matching both the disposals of the decree from April and the regiments established 1 month later, we can conclude that this body had two functions that enable it to censor and supervise all sorts of texts, books, conclusions, notes, additions to editions on philosophical, literary, political, juridical, and other scientific subjects, handwritten or printed, presented voluntarily or not. Regarding the prohibited writings, in order to prevent its dissemination and to guarantee the achievement of the primary goal of this institution, all printers were obliged to send a copy of each work to the courts' warehouses created specifically for this purpose. This measure did not erase the taking of complementary procedures such as the inspection of bookstores, booksellers' and merchants' warehouses. As it was mentioned in the Portuguese legal text from 1768, the major goal of the censorship was centered in the works of the perverted philosophers of recent times, along with the texts published anonymously in the Netherlands and Switzerland, attributed to lawyers from the French Parliament, and the works of authors linked to the Jesuit order, that is, all sorts of writings that could compromise the notorious, inescapable, and unavoidable right of temporal sovereignty, to quote the legislator's expression. Beyond this specificity, we must remind that even the lessons written by the university professors and the final theses submitted by the students were carefully analyzed and appreciated by the censors as any other text. Out of this tight control were the licenses to read books that could offend the faith, although the ability to track the abusive use of those documents were under the surveillance of the same court. Apart from the list of publications that were preliminarily classified as forbidden, category recognized to the so-called impious, false, reckless, blasphemous, heretical, schismatic, seditious, all sorts of scripts should be declared, as it happened with the private libraries that were compelled to send detailed and complete lists of their collections in which the texts should be assembled according to 7 categories: theology, jurisprudence, philosophy, mathematics, medicine, history, and fine arts. Identical obligation was imposed to the owners of the ship cargoes. One complementary explanation regarding the expurgatory index must be mentioned. That is, until this new list was not redacted, the regiment of 1768 established a set of 17 rules that defined which sort of understanding should be followed before declaring a text as a prohibited one. Among these restrictive criteria, the 13th rule presented an exception by declaring that the books written by the Protestants tolerated as a consequence of the statements presented in Münster and Osnabrück, namely Grotius, Pufendorf, Thomasius, and Wolff, were excluded from censorship because it was not customary for them to be banned in the Roman Catholic states. Otherwise, they would have to deprive the Republic of Letters of the vast and unuseful instruction of such erudite works. The opposite reasoning was applied to the 14th rule, which immediately targeted the works of Voltaire, Diderot, and Holbach, that flooded the Orbe Literario with metaphysics tending to Pyrrhonism and incredulity, impiety, or libertinism. One last consideration about these 17 rules, in particular the rule number 16, that allows us to foresee one of the most important changes applied to the coeval Portuguese legal system, in which the doctrinal interpretations due to the jurisprudential schools from the Middle Age were about to reach their end. In other words, in the following year, to be more precise, according to the disposal presented in the legal text dated from the 18th of August, 1769, these sources of law were rejected as subsidiary law. Every single time the previous rules were violated, the penalties fixed in the legislation from 1768 and in the ordinances of the kingdom, a compilation of legal texts from 1603, ought to be applied by this royal institution. Among the set of punishments once established, the offenders could be sentenced to imprisonment combined with the confiscation of all copies already printed, or be condemned to the payment of an amount of money. In the case of recidivism, the offender was sanctioned with exile to Angola for 10 years. Regarding all these rules and procedures, 2 months after the creation of the new royal court, an extensive notice of prohibited books dated from the 14th of June was published. In addition to this measure, the first conviction to the penalty of fire, a sanction that sooner became quite common, was applied to a text entitled Apologetic Letter, written on the 30th of April, 1686, by a Jesuit priest and a well-known preacher called Antonio Vieira. In the years to come, many other texts were not only banned but also submitted to the penalty of fire. If this condemnation was the most extreme decision, other possibilities were admitted, such as the introduction of corrections, cuts, adjustments, or, in the best case, the admission of the script. Nevertheless, it is important to clarify that the royal court's judgments did not admit any kind of appeal. Excluding the decisions relating to political matters which were necessarily decided in plenary, or the cases that due to their delicacy or gravity were submitted to the sovereign by the crown prosecutor, the remainders had to be decided by the majority of the deputies. Among the various convictions handed down by the Royal Censorship Court, shortly after its creation took place the most emblematic case involving the Bishop of Coimbra, Dom Miguel da Anunciação, author of a pastoral letter in which the works of Febronius were compared to the Encyclopedia and other Enlightenment titles. For this reason, the bishop was accused of establishing an association between the writings of Louis-Élie Dupin, Febronius, and some prohibited texts. The judicial proceeding took no more than a month since the publication of the mentioned letter and the execution of the judicial sentence that determined the seizure of all copies and the imprisonment of the clergyman that lasted until 1777. In this case, other well-known characters also played an important role, such as the friar Manuel do Cenáculo, one of the ordinary deputies responsible for the judgment, and in a few years' time also president of the mentioned institution, and Antônio Joaquim de Pina Manique, a Lisbon criminal judge and one of the brothers of Diogo Inácio de Pina Manique, the future responsible for the general policy in tenancy. After following a model that lasted for more than 2 centuries, the Enlightenment allowed the sovereign to build a solution whose structure was based on a secular and specialized judicial institution recognized to censor and supervise written documents. This sort of answer can easily be understood in a moment that the goal was focused on the centralization of the political power. Naturally, that the new option did not please the Holy See, that did its best to revert the situation, but there was no returning point, even after Queen Mary I acceded the throne in 1777. In this moment, despite her deepest religiosity, when the question arose again, the monarch preferred to maintain the previous political and legal solution. During the next decade, this royal institution received another name, that is, General Commission Board for the Exam and Censorship of the Books in 1787, sustained by some minor administrative changes, and 6 years later, in 1793, the 16th century tripartite censorship model was restored. To conclude, the third and final replacement arrived in 1821, when the defense of the new ideas led to the foundation of another institution with identical legal nature, but this time classified as the Supreme Court for the protection of the freedom of press. According to an optimistic perspective supported by the founders of the Portuguese liberalism, the oppressive and repressive regime that had characterized the Portuguese cultural universe was about to be left behind. Unfortunately, the subsequent years showed us that it was no more than a mere expectation drawn up in those early and revolutionary days. Thank you very much for your attention.